All right, welcome everybody to day two of the Legal Survival Guide training. My name is Anya Lusk. I was the one that was answering your questions yesterday. And here with me today is Kevin Sutton, who was presenting yesterday. We're doing a complete role reversal where I'll be presenting and Kevin will be the one answering questions that anybody has to ask. If you would like to ask a question, you're probably familiar enough with Zoom at this point to know that there is a chat window and there is a Q&A window. The chat window is going to be disabled during this presentation. So if you'd like us to answer any of your questions, please use the Q&A window instead, and Kevin or I will get on it very quickly. So to give a very brief recap of what we went over yesterday, if you were able to attend, and also if you weren't, Kevin spent some time talking about exactly what the Legal Survival Guide is, and he did such a fantastic job that I do not plan on repeating any of it here. He then went to talk about the very crucial and critical importance of ensuring that your school's policies and administrative regulations and student code of conduct, annual notifications, and if your school uses them, your athletic code of conduct too, are all consistent and that they all say the same thing, because as we all know, we can get into some trouble sometimes with parents and discipline, with a whole bunch of different situations if those different documents don't all end up saying the same thing. He then discussed student-centric policies and administrative regulations, our model student code of conduct, and our model quote-unquote general policies and administrative regulations. So my plan for today is to talk about the remainder of the Legal Survival Guide, and that's sections 2 and 5, and those would be model annual notifications and our model forms. And if there's time, I would also like to talk a little bit about the model table of contents that we have at section 6, all the way at the end of the Legal Survival Guide, which if your school prefers to use the student handbook, they can look at the table of contents there to see what's typically in student handbooks, see where some of those things exist elsewhere in the Legal Survival Guide. And the table of contents also holds a ton of references, a ton of links to places such as MDE, where forms and other information exists. And after that, so I'm going to talk about that for about an hour today. And after that, Kevin and I are going to give you kind of a little pop quiz on what is in the Legal Survival Guide and really what they are scenarios. And we're going to take some time to walk through step by step some very common things that occur in schools and where that information, like I said, can be found in the guide. And if it can't be found directly in the guide, where that information might be found elsewhere. So before I get into all of that, I did want to take just a few minutes to talk about some of the more frequent questions that we've been asked lately about COVID-19. And the last time I checked, which was earlier, it was yesterday, about 40% of Michigan is vaccinated at this point. And I also noticed when I was doing my research that COVID cases among school-age children are rising rather dramatically and have been rising a little bit, unfortunately, over the past couple of months. So keeping all that in mind, the question that we get asked a lot is, can schools require students to be vaccinated before they're allowed to return to on-campus classes? And like with most things related to COVID, there are no hard and fast rules quite yet. However, there are some key things that you should keep in mind. Under the revised school code, the Michigan Department of Health and Human Services is the governmental entity with the power to determine which vaccinations students are required to have and which ones they don't have to have before they're allowed to be enrolled in school. And as of today, and by that I mean 8:55 a.m. this morning, which is the last time I checked, MDHHS has not released any information suggesting that they're going to be requiring students to be vaccinated before they come back to school. So that being said, as we all know by now, things with COVID, they change dramatically, they change overnight, they change from morning to afternoon and then flip-flop in the evening. So that information is good as of right now, but of course it could change even by the time this presentation is done. But as things stand right now, schools cannot require that students be vaccinated before returning to school. Things are a little bit less cut and dry for employees right now. So the next question is, may schools require employees to be vaccinated before they're allowed back on school grounds? And the answer is possibly, but it depends on a few quick things. So the main difference is for employees that are subject to a CBA, or employees that are members of a union, and at-will employees who are not members of a union. And for employees who are members of a union and therefore subject to a collective bargaining agreement or CBA, whether or not the employee must be vaccinated is very likely going to be a condition of employment. And for any of those of you that are familiar with the phrase condition of employment, there's probably a whole bunch of alarm bells going off in your head. And for those of you that are less familiar, very briefly, a condition of employment is something that both the union and the school agree to before an employee begins working. And it commonly includes things like salary, time off, work holidays, things of that nature. And it also includes things that an employee must do before they're eligible to be hired as an employee, which would include whether they must be vaccinated before they come to work. So the answer for employees under CBAs is that if a school does want to require employees to be vaccinated, it's something that the school district is going to have to negotiate with each of the unions before it can be a requirement. Now, you might be thinking, okay, great, Anya, I know how unions work, I know how CBAs work. What about at-will employees? Employees that are either employed under a contract or just hired by the school district. And for that, the answer is a little bit different and unfortunately not at all clear at the moment for employers that are government entities such as school district. And in fact, there's some very, very key litigation going on right now over whether government entities like school districts are allowed to require at-will employees to be vaccinated. So unfortunately, there's no straight answer at the moment. And until there is, I would recommend that school districts keep up with all of the incredible safety guidelines that you have in place right now, maintaining distance, wearing masks, washing hands, all of that, until the issue is a little bit more solved to ensure that everybody is as COVID-free as absolutely possible. All right, so now I'm going to turn my screen, if I can do it successfully, over to the legal survival guide. So the first thing I'm going to be talking about today are annual notifications, and this is under section 2 of the legal survival guide. And for anybody that's been in the school world for at least a year, you're probably very aware of annual notifications. And what they are a mix of federal and state law that say something rather simple. At the beginning of each school year, or when a new student enrolls at the district must provide that student's household with a copy of certain things. And those certain things are everything that's contained here under section 2 of the legal survival guide. So the first, and so schools know, historically, a lot of schools would send out a packet of information, and our annual notifications, I believe, are 8 pages long. So it's not too long, but for some of the bigger schools, that can be quite an expense if you have to print and mail out this document to every household, every student household in the school district. And so a lot of schools have been turning over the process to electronic means, which can potentially bring up some potential equity issues, but you are able and are permitted to send out annual notifications electronically if possible, but be sure that if a student or a student's household or student's family does need written copies, that you are providing an actual printout for every student who might need one. So Kevin talked a little bit about FERPA yesterday, but I wanted to go into a little bit more detail today. So FERPA is a federal law, the Family Educational Rights and Privacy Act. And what it does is it requires schools to get consent from either a parent or a student over the age of 18, or 18 or older rather, before the school is allowed to release or disclose information about that student's education records. And education records is something that's very specifically defined under FERPA. And essentially anything it is a document an electronic recording, a video recording, any sort of media whatsoever that contains information that could identify a student if it was released to someone other than the student or their parent. And the reason that it's so important for schools to follow FERPA is because if a school doesn't get consent from the parents or the student, if the student's 18 or older, the school could possibly be at risk of losing some federal funding, which we all know is a big no-no. So it's important to get consent before you release information about a student to anybody who asks. So that being said, there is some information that a school district can release about a student without first having to get consent from the student or the parent. And all of that is included in these bullet points right here. Includes the student's name, address and phone number, photograph, birth date and birthplace, whether the student participates in school district related programs and extracurricular activity, academic awards and honors, other honors and awards, the student's height and weight if they're part of an athletic team, and the student's date of attendance at the school, and if they graduated, then the date that they graduated. Now, something to keep in mind, while FERPA is a federal law, there's actually a Michigan equivalent and under the revised school code, and the Michigan equivalent requires a couple of things that FERPA does not. And this law came out a couple of years ago, so hopefully most of you guys are familiar with it, but for those who aren't, I want to make sure that we discuss it. So Michigan shortens the time by which someone is, shortens the time by which the school district is required to respond to someone who's requesting student information under FERPA. So under FERPA, you have 45 days to get that person the information that they're looking for, and this includes the parent or the student. And under Michigan law, you only have 30 days. So if you have 45 days stuck in your head for FERPA, just know that under Michigan law, it's actually 30 days, and you'll need to abide by the 30-day requirement. So that's important to keep in mind. In addition, Michigan law requires that as part of your annual notifications, and I'm talking about this paragraph right here, Michigan law requires that school districts can include a list of, in their annual notifications, of when directory information is most typically used during by the school district. So those times when, for example, a lot of schools publish photographs of their students on their website. That would be an example of what you include under this list here. So before your annual notifications go out, you do need to include that list of things that, of times rather, where directory information is most commonly just given out or commonly used. So make sure to keep that in mind. So another important aspect of FERPA is what's called opt-out forms. And what opt-out forms are a parent's ability or a student's ability, if they're 18 or over, to say that, hey, I know you're my school district, you have this list of things that you will release to the public if requested, or that you may release yourself, like photographs on the student or on the school website, but I still don't want that information released. So what a parent or student can do is within 30 days of receiving an annual notification, or really any time during the school year, really any time during the school year, the parent or the student can fill out something called a FERPA opt-out form, and that will absolutely prevent the school from releasing any information about the student, both things that are private and protected under FERPA and this list of directory information. So before you post a photograph online, before you talk to, a local newspaper about a student, make sure you know whether that student has a FERPA opt-out form in their file, because you will have to abide by it. And part of Section 5 of the Legal Survival Guide is a list of common forms and sample forms that we use. And one of those is the FERPA opt-out form. So if you haven't seen one before, or you'd like to just kind of get a glimpse at what we might be doing with it, we'll be discussing that a little bit later. There's also a couple of other times where you're allowed to release student information to other entities. One is the United States Armed Forces. This is something that is explicitly stated under FERPA, that you're allowed to give that information to the United States Armed Forces, but also that a parent is allowed to say that the armed forces are not permitted to obtain your students' records. You can also give student records to other school districts that the student enrolls at. So part of what occurs when a student enrolls in a new school district is that the new school district calls the old one, gets a copy of that student's file, and school districts are allowed to exchange those without being in violation of FERPA. All right, the next two sections are pretty self-explanatory. This is notice of asbestos in school buildings. Chances are that if years and years and years ago that your school district or your school rather abided by the Asbestos Hazard Emergency Response Act, which is where they had an expert come in and see whether or not there's any asbestos in the building and a plan to remove it. So that building inspection plan and the management plan of where asbestos might exist and how it's removed should be available in your building's main office, or should be available in a place and location where all the staff is aware of it, so that if employees or parents want to come in and take a look at it, that they're able to. Pesticides is pretty similar. The school board is required to ensure that a district is pestilence-free as possible, and they do that by creating something called an integrated pest management program. And what that involves is some outside companies or inside, if you have the resources, coming in and spraying for pesticides every now and then. And schools are required to inform parents when pesticides may be sprayed. So that's something to keep in mind. All right, drug-free environment and protection. So as you may be aware, a school can designate that that up to 1,000 feet from the boundary of any school property is a drug-free school zone. And what this means that anybody that's carrying or delivering or selling or anything like that, drugs in that area, it's subject to some higher standards, some more scrutiny than I suppose if they were selling drugs elsewhere. So what this annual notification does is give student households actual knowledge that the school has specifically designated the 1,000 feet around a school property to be a drug-free zone. All right, discrimination and harassment. This annual notification deals, of course, with discrimination and harassment in the school environment. Kevin spent a lot of time yesterday talking about Title IX and about bullying, which also kind of get wrapped up into this discrimination and harassment annual notification. And essentially what it says is that no person can be denied admission to the school based on illegal reasons such as race, such as gender, such as national origin, such as religion. And that if anybody believes that they have been discriminated and harassed against, they are able to contact the information that the school will supply in these highlighted fields here. And that usually is the school district civil rights compliance officer / Title IX coordinator, who's often the same person, and where they might be able to contact them. All right, this next section, 2.6, deals with the McKinney-Vento Homeless Assistance Act. And this is the school district's pledge that under that law, that any students who are homeless or are in kind of a transition phase of their life, living between different areas or different homes, will still be eligible to, of course, receive a free public education at the school district. And at the bottom here, you include the name of your the coordinator, the person who's responsible for ensuring that that this law is followed. All right, parental inspection of instruction materials. This is a Michigan-based law and also kind of tied into Title I and the Title I funds that a school receives. And all it discusses is how parents are permitted to review their child's curriculum or the instruction materials, things like textbooks and workbooks and things like that, provided to their student. And they absolutely are permitted to request that information and to look it all over. So the next two sections kind of run together a bit. It's school property and search and seizure. And they talk about two main points. First is that students do not have a reasonable expectation of privacy for things like the clothing, do not have a reasonable expectation of privacy when it comes to lockers that are provided by school districts for their use. And this means that schools are permitted to look through student lockers without first having to obtain consent from the student which is a pretty big change from, kind of a bit far in the past, where schools had to ask permission or have reasonable suspicion before they could search a school locker, and now they don't. And the reasoning for that is because it's property that the school district owns and lends to students, and as a result, it still is the school district's property to search through as it may. However, and as Kevin discussed a bit yesterday, students do have a reasonable expectation to privacy for the things like the clothing they're wearing and the pockets in that clothing, for their backpacks and purses, and for oftentimes vehicles that are parked on school property. And what this means is that schools generally cannot search these areas unless they either have consent from a parent or they have reasonable suspicion that illegal contraband, or that they have reasonable suspicion that when they search that area or search the property, that it will reveal that the student has committed a violation of the student code of conduct. So keep in mind, with section 1.6 of our student code of conduct actually gets around the vehicle search issue by saying that if any student parks in a school parking lot, it is a privilege to do so, and that by parking there, they are automatically consenting to their vehicle being searched at any time and with or without notice. So that's how our student code of conduct gets around the reasonable suspicion requirement.
Hey, Anya. Good morning, everybody. This is Kevin. I'm going to stay off camera today because you saw enough of my face yesterday. But I want to just pause here really quick, because I think what you're talking about, Anya, is so vitally important. And it comes up a lot, and it particularly has come up a lot in recent years, where we've got kids that are leaving their vape pen sitting on the passenger seat, or they've got a bag of oregano sitting on the dashboard that we can very obviously see, and we get kids and we get parents who say, well, you can't search, that's my private vehicle, that's my car, you can't search that. And what Anya's talking about is, not only have we addressed that from a consent standpoint other places, so they've already consented in recognizing that we can do a search if we have, of course, that reasonable suspicion, but they've in essence consented to that by coming on our property. And so many of you have probably dealt with this situation where there's a kid in a car, and who knows, maybe we see something, maybe the drug sniffing dog is barking at it, whatever the case might be. Should we go and start trying to search cars just for the heck of searching cars? Of course not. But the idea that somehow it's this protected area that we're not allowed to enter is something that is not the case, and we've addressed that both here with these notifications and in the code. The last thing I would say is this: if you're in a position where you're going to search a car, should you be searching the car, or should you be having the police search the car? I think you, as the school administrator, because you're trying to enforce your student code of conduct, you're trying to enforce your district policies, you should be doing the search. You don't want to be identified as being an agent of the police, or having it somehow look like it was a police search and has criminal implications, so on and so forth. So there may be a few questions around that when you get to that moment, but just know that student vehicles absolutely can be searched, assuming we have good reasons to do so. And the fact that it's their car and not ours does not prohibit us from looking into the vehicle. Sorry for the interruption, Anya.
No, absolutely. Those are all excellent points. All right, so the next two sections, section 210 and 211, talk about special curriculums and special education services and education resources that schools provide their students. This is an acknowledgement that, yes, of course, our school district provides special education and related services and services under section 504 of the Rehabilitation Act for students that might be educated under IEPs or section 504 plans. And 211 does something very similar, where it talks about personal curriculums and the fact that students are allowed to have personal curriculums as part of their education plan. And this personal curriculums, they're very specific requirements. We've included a link here under section 211 that leads to MDE's, the Michigan Department of Education, MDE's website, to talk about exactly what needs to go into a personal curriculum before a school can use one for a student. All right, section 2.12. This is student privacy and parental access to information. And this is a federal law, and it's right there in the books next to FERPA. And what it says is that schools are not allowed to ask students pretty specific questions about their family. And the list of things that that schools can't ask unless they have consent from a parent are included here in the bullet points. Schools rather cannot collect information about students' parents' political affiliations, mental or psychological problems, sexual behavior or attitudes. All this is a big list of things that they can't ask unless they have consent from the parent first. Section 1213, Title I funds, and you know how important Title I funds are if you've been in the school district world for a while. And this is parent involvement. It's also referred to as parental and family engagement. That might be the other term that you've heard. And what this means is that parents are allowed to come to a school and ask questions about the student's teacher, ask questions about the student's curriculum, object to the curriculum, and obtain really the knowledge that they need to understand what their child is being taught. And the reason that this is important is because school districts want to work, or hopefully want to work, and maintain positive relationships with families and the community by making sure that the community knows exactly what is going on and that parents know what is going on with their students, with the teachers at the school, and with the textbooks and other sort of material that students are being provided. Program for English language learner students. This is pretty straightforward. Schools provide English language classes and resources for students who are not yet proficient or working towards proficiency in the English language so that they can benefit as best as possible from the public education here in Michigan. Child nutrition program. This is also better known as the free or reduced price meals program. And every single year, the United States Department of Agriculture releases a list of the income requirements for families to be on the free or reduced price meals plan. Historically, we've included free. There's two different lists for reduced price meals and free meals. And actually recently, the United States Department of Agriculture has said, hey, don't include the chart for the free meal plans. And so we've taken that off of our annual notifications. But if you've been with us for a few years, you'll know that our prior legal survival guides did include the free price meals, but now they don't, and that is why. And so what this does is also list where on the school's website the application for a student to apply for the free or reduced price meal plan exists, who they can contact at the school, and there's actually at the very end, one of our forms is we recommend actually if you do mail this out to somebody or if it's sent to students electronically, you actually include the application itself attached to the annual notification so that students and parents don't have to go digging for it if they need it. I'm not going to talk about the wellness policy. Kevin talked about that pretty at length yesterday, but part of the law around the wellness policy does say that we have to let parents know that a wellness policy exists and where they might be able to find it online. So the last annual notification we have here is for physical examinations and screenings. And again, Kevin mentioned a little bit of this yesterday when he was talking about the student-centric policies and administrative regulations, because not only must notice about physical exams and screenings be included as an annual notification, it also must be contained as an actual policy in your board's policy manual. So what this says is that in the absence of an emergency or an IEP or Section 504 plan, the school district does not provide physical examinations and screenings on school premises. And the reason I'm saying this is because your school might in fact provide physical examinations and screenings on school premises, a very common one being vision tests in kindergarten and in 6th grade. So if your school does provide physical exams and screenings, make sure that if you use these annual notifications that you amend them to reflect that fact. That being said, what we have included here is that parents may submit a physical examination screening opt-out form. So even if the school does provide these sorts of exams and screenings on school premises, parents can still say, no, I don't want it. I don't want you to provide it to my student. I'll do it myself, or I'm just not interested in this particular service. So if a doctor does come, if you have an outside clinic come in and do these physical exams and screenings, make sure that all of the students who get them do not have one of those opt-out forms in their file, and it's very important. So those are annual notifications, very exciting stuff, I know. Again, friendly reminder, they have to be sent out at the beginning of each school year to all student households, and they also need to be sent out to any student households that are enrolled at the school district at any point during the year.
Hey, Anya, I'm going to jump in here really quick, and we've had a handful of questions that I've been typing away here while you've been talking. But I've got one that just popped in, and it's a good question, and I'm gonna ask it. I don't know that either of us know the answer. Maybe you do. Right. It says, is a temperature and a BP check considered a physical exam? So would that apply under the section 2.17?
It not only would apply under 2.17, but there's actually a very, very good argument to be made that that's actually considered a search and seizure under the Fourth Amendment to take that information from a student. So we do not recommend, in the absence of an emergency, do not recommend, or in the absence of an assumed emergency, do not recommend taking temperature or BP if it can be prevented.
Well, I assume the natural, and that's fair. I assume the natural next question is, well, we're taking temperatures right now because of COVID. So is that an illegal search and seizure? Nobody asked that, but I assume that would be the next logical question, right?
That's fair. And that actually, I do think constitutes an emergency exception, because COVID has been, the whole government was shut down, has been an emergency situation, and we're still not necessarily out of the woods yet. So I think that is a perfect example of one of the exceptions, because what we don't want is a whole bunch of students, of course, coming to school if they're sick, and then, passing it along to the other students.
Yeah, no, I would agree with that response. The other thing I would say to that is, if a student has a BP check as part of their 504 plan or their IEP or something, and we're using a school nurse to do that, that obviously would be okay. Yes. But I think Anya's point is, absent some exigent circumstance, either because of a global pandemic or because of a student document that would provide us permission to do that, we shouldn't be going around and taking people's blood pressure just for fun. I think is maybe a good way to say it. I had another question pop into Anya. Mm-hmm. Does the physical examination screening policy include vision and hearing screenings provided by the local county health department?
If the local county health department comes to the school and that's where the students are tested, yes, that is literally exactly the purpose of this physical examination screening policies, for things like that.
All right, perfect. With that, I think we've cleared the deck of annual notification questions.
All right. Then I will move on to model forms.
Everybody's getting hyped now. Model forms. Everybody loves model forms.
Come on. Excited. I love model forms. All right. The first form is the Model Student Code of Conduct Acknowledgement of Receipt. And it's pretty straightforward. What it says is that by signing and returning this form to my building principal, I acknowledge I've received a copy of the Student Code of Conduct. I read it, I've understood it, and I know that I'm bound by the expectations rules contained therein. Very importantly, it also says that I also understand I am still bound by the Student Code of Conduct, even if I did not read it or did not return a signed copy of this form to my building principal. One of the questions that was asked yesterday are, well, hey, great, we have these acknowledgements of receipts, but what if a student doesn't send one back? Are they still bound by it? And the answer is absolutely, unequivocally yes. In fact, you don't even need this language for me to tell you that students are bound by student codes of conduct if they're used and implemented in a school district. This just gives the school district a little extra protection. If a parent says, well, I didn't know Johnny couldn't bring a knife to school, and you can say, actually, you did. Here it is. It's right here in this form that unfortunately you did not sign or return to the school, but Johnny is still bound by the rules and regulations contained therein. So this acknowledgement of receipt requires both students and parents to sign it. You can have underage students sign it as long as the parent signs it too, or if the student's 18 or over, you can just have the student sign it and you don't need the parent to sign it. All right, so this is the model for opt-out form that I was talking about earlier as part of our first annual notifications. Depending on what your school typically uses, this can go one of two ways. What we've included here is a blanket opt-out form where if a parent signs it, then the school can release none of this directory information to anybody who asks for it. And that would include, very importantly, a student's photographs. You cannot put photographs taken of a student in school on the district's website if a parent has signed this opt-out form for their student and submitted it to their building principal. So that's an issue that can come up sometimes, so it's something to keep in mind. Your school might have one where a parent can, have check boxes next to each one, say, yes, you can use a photograph. No, you cannot give my student's address to anybody who asks. But we just have a blanket one. And then typically, like I said earlier, these have to be returned to the school building within about 30 days after the annual notifications are provided to a student's household. But really, to keep yourself safe, to make sure everything's on the up and up, anytime you get one at all during the school year, abide by it. So even if it comes, 2 weeks to the end of the school year, it's a good idea to do so.
Yeah, just Kevin, again, just one quick commentary on this one. Some districts too will, as Anya said, not only break it out with individual check boxes, sometimes they'll have a separate form for media opt-out or photograph opt-out. I like to tell the story. It's a few years old now, but the school year started. My son was in elementary school, and I was following the teacher's Twitter page, like every good parent should do. And she was posting photos of the kids doing various projects and whatnot. And a couple photos, like I knew they were my son because I, was here when he got dressed in the morning, and there was like a paw print over his face, and you couldn't see his face. And I was like, after about the second or third one, I was like, what the heck's going on? Did she think my kid's ugly or something? Why is she covering his face? And so I called up to the school, and they pointed out to me that in my haste at the beginning of the year and filling out the pink cards and signing forms and writing a check to the PTA, I had actually signed the media opt-out form. I hadn't signed the general opt-out form, but had signed the media opt-out form. And that's why my kid's face had a little cougar paw print over it, so you couldn't see him. And so some districts break this stuff out. Parents don't always understand when they see a definition of directory information. They see all these categories, what it might mean. And so particularly on the media stuff, because we're doing so much of that now, right? Most of the schools have their own Facebook page. A lot of the teachers, elementary and otherwise, have Twitter feeds, so on and so forth. And so I think that might be something you want to look at in terms of breaking that out. But all of this language is here, and hopefully you don't have anybody who acts as hastily and ill-advisedly as I did and has their kid's face being covered by a paw print when they don't want it. So thank you.
All right, here's the physical examination and screenings opt-out form, as we talked about earlier. Again, the language of this form as it is right now says that the school district does not provide physical examinations and screening. So make sure that if your school does do that, if you have a local county coming in, a local county health department coming in, giving vision and hearing tests, that you amend this language to state that, yes, in fact, the school does make physical examinations and screenings available to students. Again, if you do that, make sure that you look, as Kevin was mentioning with the paw print, make sure that you're very specifically checking that every student that's getting the physical exam or screening has not, their parent has not opted them out from doing so. Because again, there's some federal funding tied to this under a federal law, and we want to make sure that we keep as much funding as possible. This is one of the easier ways to ensure that gets done. Medication authorization forms. So this is the form that we recommend that schools use when a student is required to administer prescription medications to themselves or required to take prescription medications while at school. And not only is the parents have to give permission to the school, but actually this form needs to be filled out by the student's physician, stating what medication, names or the names of the medication the student uses, the dosages, dosage instructions, which means where or what times rather the medication needs to be taken, where the medication needs to be taken if it's an injectable, the diagnoses of the student that requires this medication, any other information that might be in there. And the student's physician specifically has to sign this document before a school is permitted to let a student take medication at school. And this also can this medication form also contains a statement saying that in for the most part, so this form, there's two different types of forms, just briefly, that we're going to go over. This one is when a parent needs to come into the school during the school day to give their child a medication, and that might be because the student has an impairment of some kind that prevents them from giving the medication to themselves, or because the student's too young to ensure that, or to be able to understand the medication that they need to take and at what times and all that. And if that's the case, then the parent themselves must come into the school, or another guardian or someone that the parent approves must come into the school to give the child the medication. The school district is not required to administer the medication unless this form is signed out, where it says, I authorize the school to administer or attempt to administer the child's medication as described above. The second medication form we have is I'm sorry. Well, let's look at this one then. Anyway, this form talks specifically about EpiPens and asthma inhalers. And this form is one that needs to be filled out again by the parent and needs to be filled out by the physician. And how this form differs from the previous one is that it specifically states that the physician themselves is saying that I certify that the student listed on this form has been instructed in the proper administration of EpiPens or asthma inhalers, understands when they should be given, and is capable of giving it to themselves. Now, just so everybody knows, in case you're not aware, there is a law out there that says that school personnel, in the event of an emergency that threatens the life of a student, may give a student an EpiPen themselves. And what the law does, recognizing that it is crucially important that if a student is having a severe allergic reaction, that they be provided with the medication they need in order to be okay, unless the school district personnel are really protected very well against the law from any accidents that might occur. And this is a great thing because it makes it so that school personnel should feel free to give EpiPen injections if a student is suffering a life-threatening emergency, without worrying that they may, mess it up and may not give it properly. That being said, school employees will possibly still be responsible if they were grossly negligent in administering it, which you'd have to, frankly, mess up pretty badly trying to give an EpiPen injection for that to kick in. So school district personnel should feel free, if they're comfortable, to do this if they see that a student is having an allergic reaction. So this not only covers EpiPens, of course, but it also covers asthma inhalers, and that a student is able then to carry the medication around with them if it doesn't need to be refrigerated, which neither of these do, to the best of my knowledge, and give it to themselves when necessary. So this form is, again, a little bit different than the previous two. And what this is a self-medication authorization form. And what this form does is allow a student to give themselves medication while at school. The medication is typically kept in the front office, though some schools do permit students to walk around with the medication if they might be taking it multiple times during the day. This form also has to be filled out and signed by the student's physician saying, yep, I certify as a medical practitioner, completely aware and familiar with these things, that the student is capable of giving themselves medications, capable of determining the dosages, and that the student understands when the medicine should be administered and what the side effects might be, and that especially to report to school personnel immediately if the student doesn't feel well after taking the medication. And so this form specifically allows the student to carry and administer the medication without assistance. So the student would not have to come to the front office if they don't need to, although they might want to, or the parent might want them to, but they can just carry the medication around with them while on school grounds. So this not only, of course, allows the student to give themselves or administer themselves medication while at the school, but also while at any sort of district event or function. So those are our model forms that we have. I know that yesterday in the Q&A, window. Someone had asked for copies of our athletic student code of conduct and an equivalent acknowledgement of receipt under that. So I gave that out to a couple of people who had asked for it. But that's what we have. So.
Well, good stuff, Anya, and we've had some questions coming in that I've tried to respond to as best I can. Bob Kefkin just asked a really good question about opt out from screenings and COVID symptoms and how that gets handled. And so I gave somewhat of a long-winded and vague answer back to Bob in that, some counties, but just for everybody's benefit, some counties and school districts have taken the position that if a student wants to opt out of symptom screening, they can, subject to the parent certifying that the student isn't experiencing any symptoms. I feel like, and we've alluded to it a little bit this morning, in this last 14 month of COVID era, we've tried in many instances to sort of emergency exemption everything,
Yes.
where we say there's an emergency and so we can start doing all of these things. And I don't mean that as a political commentary in any way, shape, or form, but I think we've created a bit of a gray area where, depending on how flexible your health department is, some districts are being more lenient than others, and some districts are being more stringent than others. I think at the end of the day, and Bob didn't ask me to take a position, but I will try to take a position. I think at the end of the day, if you wanted to take the position that you weren't going to subject your kid to daily screening, but you still had to give some sort of certification. I mean, obviously, there's an overarching public health concern that probably you probably couldn't push that as the school. I'm not saying that anybody should leave this webinar this morning and throw out their protocols. I'm answering more of an esoteric question based on Bob's query, but it really is a case by case, and Anya knows as much as anybody. We hate giving case by case, it depends, factual specific type answers, but I think, as we've learned in the last 14 months with COVID, almost every situation has to be assessed individually, and it's going to be based on your county, it's going to be based on your locality, your local rules, etc. And frankly, which way the wind is blowing that day with COVID and the overall government engagement on the topic. So I don't know if Bob was satisfied with that answer or if anybody else is, but that's what I told him. And I think, Anya, there's no other questions in the queue, but I think just a really important moment to sort of pause here before you jump into the table of contents, and then we move to the very important scenario work. And it's not just because I feel the need to use the word cohesion repeatedly, but why do we talk about this? Don't look at what Anya talked about this morning with the notifications and the forms sort of in a vacuum. Think about it as a continuation of what we talked about yesterday, right? So when we're looking at the student code of conduct and we're looking at policy language and administrative regulation, we want alignment across the board. Yes, forms make it easy to send stuff out to moms and dads. That's fantastic. But notifications are legal requirements. They're things that we have to do, as Anya said. And a lot of districts have very bare bones notifications that maybe don't cover everything they need to have. But it's so important not just to check off the box of saying, look, we did it, we covered everything that we need to do. That is step one in getting that cohesion. That is step one in getting that alignment, which flows from the notifications to the code, to the policy, to the reg. And so I'll keep saying it till I'm blue in the face, because it's so important with the overall organizational operation of a school district that we have that alignment and we have that cohesion across the board. But that's why it's so vital, and that's why we spend such a considerable amount of time talking about it and emphasizing it, because when in the districts that we work with, having that type of alignment makes it a lot easier. If ultimately the job of the attorney is to clear roadblocks, right? Provide legal solutions so teachers can teach and students can learn. Having these things in alignment enables us to do that and enables you to be in the position to do so. And that's why we think the guide is so important, and having this type of I'll say it one more time, cohesion and alignment is so important. But all right, Anya, I'll get off my soapbox. Hopefully we have true believers at this point, and I'll get off my soapbox and let you jump to the table of contents.
Sounds good. And I, of course, agree with everything that Kevin's saying. This stuff really is very crucial for just kind of the basic operation of your school district and your school, and making sure that that everybody's on the same page. So this last section that I'm going to talk about today is the model table of contents for student handbooks. Now, we do not have Miller Johnson does not personally have a model table or model student handbook. Instead, what we have is the model code of conduct. Now, the handbook talks about a wider variety of things and all of the potential topics that may be covered here, or that may be covered in model student handbooks are available here. What we've done is we've referenced the section where in the legal survival guide, this information may exist. So that if you do prefer handbooks, if you do prefer putting something like a handbook together, you can kind of take bits and pieces of the legal survival guide as you need in order to flush out that manual. So not only have we included where in the legal survival guide a lot of these things exist, we've also included a couple links to where this information can be found online. So for example, animals and school property, right? A question that very frequently comes up is, are schools required to accept animals or accept service animals, either from students or from members of the public during board meetings or during district-related events, or from even employees. And so we don't have anything in our legal survival guide about animals on school property, mostly because it's 100% covered by law. And as Kevin, I believe Kevin may have mentioned this yesterday, we're pretty adverse to just repeating the law in our policies and in our student code of conduct, because the law exists and the school is required to follow them. And so what we do instead is state how the law actually looks and what school districts actually need to do on a day-to-day basis in order to abide by the law. So we don't have anything in our legal survival guide about service animals, but what we do have here is a kind of like the definitive memo from the United States Department of Justice on service animals and what areas of public accommodation or what areas that are open to the public, like school districts, what they need to do in order to ensure they're in compliance with the Americans with Disabilities Act, which is where service animals come into play. So aside from that, we also, so here's another a link that we have, treats and snacks. So this is part of our wellness policy and part of the USDA's guidance on what types of foods that school districts are allowed to serve at school. And this is so that we have here a link to Michigan Department of Education, some MDE guidance on when it's appropriate to have treats and snacks in school and which types schools are allowed to have. We also have MD guidance on graduation requirements, if that's something that the school district, that your school wants, on AP or IB classes, dual enrollment, CTE, online or blended learning. And this was, of course, pre-COVID. This guidance is just pre-COVID for online blended learning. But if we ever, hopefully soon, get back to a place where students are mostly or primarily in school, this guidance will help a school figure out how to get a student to an online sort of blended learning program. There's testing out requirements. We have a guidance on testing out requirements, something that a lot of schools call and ask about because they don't have any really plans or procedures in effect quite yet. And that may be it. Yep, that's it. So, take a look at this. Again, feel free to kind of pick and choose from all of the available resources that we have under the Legal Survival Guide and utilize them as you like in a student handbook. Of course, make sure that the information that you choose is exactly consistent with the policies that your school district might have in place.
Anya, just to make sure I'm clear, and so everyone else is as well. If I'm not mistaken, you built this list out from sort of the existing MASSP Model Student Handbook table of contents, right? Kind of what they had.
Mm-hmm. I did build it out not just from that, but I also we work a lot with student handbooks at our job. And so what I also did was took a whole bunch of other school districts' handbooks and just try to create a most cohesive and comprehensive list of any possible thing, really, that wasn't too out there that a school district might include. But yes, I did primarily rely on the former MASSP Model Student Handbook. Yes.
Yeah, no, it's awesome, and I know it was a tremendous amount of work. I guess the other thing I would add for people is, you might say, well, wait a minute, there's a couple categories where there's not a reference specifically. That doesn't mean that we're saying you should or shouldn't have it. What we're doing is trying to tie it back directly to the legal survival guide and what we have in that great resource to use. But there are other things. For example, I think as Anya was scrolling through the list, I saw something about foreign exchange students. That's something that the board very often will have a policy on. Now, we haven't included that necessarily in this guide, but that's something. There it is. I thought I saw it. That's something that boards will very often have a policy on. Now, again, some people then, in addition to a board policy, want to specifically include it in the handbook if you decide to do a handbook type framework. And so I think in addition to providing a spot in the guide that you can find it, in addition to providing maybe a link to a memo or MDE guidance, some ideas of things that people might put into a handbook that might parallel existing board policy as well.
Absolutely.
Well, Anya, we got a question here about, do we have a reproductive health opt-out form? Do we have one of those?
We actually, that's actually a great one we should include. Now that it's been mentioned, no, we don't have one of those, but I think we should probably include that on next year's legal survival guide.
I love it. Well, I think because that brilliant thought came from one of these folks, that I think we could maybe develop a supplement that we can share. MASSP can share through its portal. That way, for having come up with the idea, you get the benefit of it this year, and then that'll be something we include going forward. I love it. We got to have a growth mindset on all this stuff, and that's a great suggestion. Thank you for it.
All right. If there are any more questions right now, then I suppose that we can just jump in right into the scenarios if you're ready, Kevin.
Yeah, let's rock and roll.
All right. So I kind of jokingly referred to it as a pop quiz earlier today, but I also kind of meant it. So what we're going to do is go through a handful of scenarios. I think there's about 7 or 8 of them to try to just test the knowledge that you guys have learned over the past 2 days, and to see some really common situations that occur every day in school districts and what is the best approach to handling them, consistent with the law and with the information that is contained here in the Legal Survival Guide. So let's get to it. Scenario number 1, a local newspaper asks for the name, date of birth, height, weight, and current GPA of every student on the varsity basketball team so they can write an article about the upcoming playoffs. Can you turn this information over? Now, what I think I'm going to do is give you guys just a couple of minutes, a minute or two, to maybe scroll or flip through the Legal Survival Guide, see if you can find where this information might be contained, or if it's in there, and then come back in about a minute or so and see what you guys got.
Yeah, and obviously, if we were in a normal environment and we could do this in person, we probably would have you grouped up in teams for that all-important collaboration, and we'd hand out 7 scenarios to 7 different tables, and then we'd report out and talk about it as a group. Since we can't do that, and we weren't going to get into the complication of breakout rooms for scenarios, we'll take the minute or so with each one, and then I will play the role of administrator, and I will tell Anya what I'm thinking, and she can tell me why I'm wrong or how I need to do it differently. But hopefully I don't fail the quiz. That would be kind of embarrassing. But we'll try to approach each one that way. And of course, with respect to any of these, as we talk about it, fire questions into the Q&A tab. We'll try to address those. All right, Anya. So here's what I think about scenario number 1. I will play the role of administrator. I would look at that and say, well, isn't this directory information? Can I hand all this stuff over? So I'm thinking FERPA. I'm thinking it's a newspaper, so it seems legitimate. It's not just some random dude asking for a list of information. And I'd probably want to figure out which of these categories, if any, apply as directory information and which don't, because I know I can hand over directory information without any fuss.
That is spot on, Kevin. That is exactly what you should do. So anytime anybody that's not the parent or the student asks for information about a student, the first thing that you should be thinking is FERPA. And then right after that, you should be thinking directory information. Is this information I can turn over? And for the information contained in this list here, There is one element, there's one of these things that the local newspaper is asking for that is not covered by FERPA. I'm sorry, that is not considered directory information, and that is the current GPA of every student. So directory information does include name, date of birth, and height and weight, and you can give the height and weight because the students are members of an athletic team. But current GPA is private protected information that you cannot give out to the newspaper. Now, that being said, if the newspaper is asking for this information about a single student, let's say, Johnny's, and you see Johnny's mom in the school, and you can be like, hey, Johnny's mom, the newspaper asked for Johnny's current GPA. They want to, give him some accolade or some written praise for being, a really high GPA student, honor roll, etc. Like, can we give the school district Johnny's GPA? And then you can get written permission from mom saying that you can give that information over, and then you can give the school news, or then you can give the newspaper all of this information. But without that written permission, cannot give the newspaper his current GPA.
So that was a trick question a little bit. I like it.
It was a little bit of a trick question. Yeah, thanks.
Well,
so
I think. Sorry, Anya, go ahead.
No, this just shows how important it is that if there's a list of information that you're asked for, that you check off each individual item against what your school district has defined as directory information.
Yeah, no, it's an excellent point. And I think, one thing that's interesting here is let's pause for a second and think about how we handle, sometimes we have in our list of directory information, academic achievements or honors. When we group our students for honors night, which many of you probably have coming up here in some form or another, we group them by category, right? Cum laude, magna cum laude, summa cum laude, but we don't actually give their actual GPA very often without what Anya's talking about in terms of specific permission to do so. And so good scenario with good things to think about there.
Right. And Kevin, you made an excellent point where honors and awards are things that are directory information. So you can award a student for being cum laude, summa cum laude, without giving away their specific GPA. And of course, never hesitate to reach out, to your legal counsel or to any administrator that may have some more experience than you with this, to make sure that you're abiding by FERPA, because again, the last thing you want to do is risk any federal funding. So, all right, that is scenario number one. On to scenario number two. You get a call that a teacher saw a student in a red t-shirt stealing a laptop from the school library. As you're walking to the library, you see a student in a red t-shirt. Can you stop and search him for the stolen laptop? So we'll give you guys a couple minutes to think about this, and then we will circle back. All right, so this is something that Kevin discussed kind of at length a bit yesterday when he was talking about some searches and seizures. So Kevin, I will do a role reversal and I'll be the administrator talking to you. So, hey, I was walking down the hallway. I saw Johnny leave the library. He didn't have a backpack or anything like that, but he was wearing a red shirt. It was just him wearing a red shirt, walking to the restroom, and I stopped him. I was allowed to do that, right? Because I got a call saying it was a kid in a red shirt.
Yeah, well, I recall my example yesterday involved a devilishly handsome guy, maybe wearing a red shirt, balded, bearded. But no, I think I'm going to remember that that was that presentation that I went to at some point during COVID, and somebody said something about TLO versus New Jersey and a two-pronged analysis. And so, if I remember those prongs correctly, one is do I have reasonable suspicion that the student violated the student code of conduct? And in this scenario, I would say, yeah. I mean, we have a report that somebody in a red t-shirt stole a laptop, and now here is a student in a red t-shirt. That's at least enough of a suspicion that I can suspect something, right? Now, the question is, so can I stop him? Yeah. Can I search him for the stolen laptop? That's what comes next. If I say empty out your front pockets, that's probably not going to work, because the second prong is, do I have reason to believe that I'm going to find evidence of the violation in the area I want to search? And so if I ask this good-looking dude in a red t-shirt to empty his pockets, that's probably not okay, because you can't have a laptop in your pockets, even as small as they are these days. You can't have a laptop in your pocket. If this red t-shirted gentleman has a backpack, yes, I could search the backpack because I could reasonably assume that a stolen laptop might be in his backpack. But I got to think very, very carefully in this type of scenario about both of those prongs and not jump to any conclusions that are not reasonably justified.
All right, scenario number 3. So a parent calls the school's principal on behalf of her 10th grade daughter, Alice. The parent informs the principal Alice is being bullied by someone online who goes to her school. The parent sends the principal screenshots of text messages between Alice and the alleged bully, in which the bully is threatening to beat up Alice after school. Alice doesn't know who the bully is, but correctly believes that 2 other students, Matthew and Keith, do know the bully's name. So this is the situation. What are the steps that the school needs to follow in order to properly investigate and resolve this matter? So take a couple of minutes to think about that, and then Kevin and I will be back to talk to you about where in the Legal Survival Guide this information exists, and a general overview of what steps need to be taken.
I don't know why, but I feel like we need Jeopardy music or something.
I know, right? It's like sitting here
humming it to myself.
I'm
humming it to myself. thinking of Ken Jennings and humming it to myself. So Anya, if I'm playing administrator on this one, I've got a lot of stuff running through my head.
Yeah.
And you really want to go to that scenario 4, don't you?
I really do. I'm so sorry. I'm like clicking everywhere.
It's going to be a good one. And frankly, yeah, as challenging as 3 is, I can understand the desire to move to 4. So if I'm an administrator in 3, I got a lot of things running through my head, right? First of all, I will just say this as a Kevin aside. We kind of assumed that maybe there wouldn't be as much foolishness going on in an online world. We've had just as much foolishness in an online world as we have in an in-person world. That this year has shown us that certainly. I remember that we had really long sections on bullying in the student code of conduct and then in the student policies. That there was a lot there. And so I definitely want to make sure that I'm going to go there and look and see what that process was, because I remember mentioning the fact that there was a lot of prescription in terms of MASSP school law and whatnot. And so as an administrator, I think my first stop is going to be to go look at what our bullying and cyberbullying student code languages, our bullying and cyberbullying policy languages, to make sure that I'm adhering to everything that needs to happen. In terms of the steps, I mean, usually when we do this in person and we've got a few more hours, we spend a lot of time talking about investigations and what investigations look like. I think, the biggest takeaway I can give on investigations, aside from making sure that I know what my code and the policy requires, is I think particularly for new administrators, there's always this desire to like rush out and start investigating. And that's good. We want to be prompt, right? We want to be responsive. We don't want to sit on situations and let them fester. We want to react when we know about something. But I also think it's smart to take a beat, right? Take a second and what are we talking about here? What policies might be implicated? What students are we talking about? Are there things that we need to keep? Is there surveillance video, like in the situation of a fight? Here, are there emails? Is there anything I might be able to get technologically or technology-wise that might help inform my investigation? If I start calling people, are they going to start deleting things? Just take a second and develop a game plan. Should it take 3 days to develop a game plan? No, it shouldn't. But taking a second to think about it before you jump in, I think is good, sound advice. Anya, I think I played both the role of administrator and Kevin on that one, and I apologize. I get going, but that's the cocktail of things that I'm thinking about when I read scenario 3.
And I think you absolutely nailed it. That is exactly what you should be doing. Our bullying policy, and the bullying statement we have in our student code of conduct lays out the step-by-step instructions for what you need to do in the event of that investigation needs to occur. Kevin kind of talked a little bit about this, but I mean, it involves interviewing Alice. documenting the interview, collecting any evidence that you might have, such as the text messages she received, even though they came from an anonymous number, getting any witness information from Alice, for example, from Matthew and Keith, or anybody else that might have some important information about the potential bullying, and then interviewing Matthew and Keith as well, and sitting them down, making sure that their interviews are not recorded, but are documented, that you take notes as they're occurring and take pretty thorough notes. Whatever information, whatever text messages, whatever Twitter messages, whatever TikTok videos, whatever they might have that also supports the or not only supports but also cuts against the possibility that Alice is being bullied. Collect all that information, and then if you do get the name of the bully, also sit them down and discuss, have an interview with them, collect information from them. And once you do this investigation, there are of course two outcomes. Either the allegation that Alice is being bullied is not substantiated, although in this case, if you have a text from the bully threatening to beat up Alice after school, it might seem a little bit more clear that Alice might be being bullied. However, there are times when you might do an investigation and conclude that actually bullying behavior hasn't occurred here. And when that occurs, you need to notify the parents of the complainant and the person who's been accused. And if bullying has occurred, there's a number of things you can do. There's discipline that might be involved. You might also want to engage in restorative practices, having Alice and the bully sit down if they're amenable to the idea and hashing it out. There's a whole range. And so I know Kevin talked at length yesterday about certain types of discipline. So there's a whole range of things that you can do in the event that the investigation does conclude, in fact, that a student may have been bullied. So that is scenario 3. Now we will finally and intentionally move on to scenario 4. Scenario 4, a teacher catches a student spray painting the side of a school building during lunch. And there's 2 things I'd like you to think about here. Who, if anybody, is the school required to inform of the incident? And can the local police department question the student at school about the fact that they were spray painting the side of a school building? Give you a couple minutes to think about it. See if you can't find where this information might be in the legal survival guide, and Kevin and I will get back to you.
All right, Anya, it might be because I'm just naturally caffeinated, but a couple of minutes just seems too long for me. I'm just so excited to talk about this. I think this is a really kind of tricky one, and if I were an administrator, I see students spray painting. I know that that's graffiti is not appropriate. It's destruction of school property potentially, so on and so forth. But in terms of required information, I mean, I know that I would want to do my own thing. And I know that we looked at vandalism and or destruction of property and sort of the list of offenses that under our student code we can't do. But I'm not sure about who to inform and if I have to do anything more than that. That's probably one that I would be really curious about as an administrator, and maybe not even be aware that there might be an obligation to contact anybody else.
Yeah, so I'm actually going to turn to the point in the legal survival guide itself where this information exists, because as Kevin was alluding to, it's actually not something that a lot of or that all school districts are aware of. And so let me get to that point. And it's in the Student Code of Conduct at section 1.5. So under the Michigan Revised School Code, school district cooperates with local police authorities, of course, in the interest of welfare of all citizens. The school district, so the Michigan State Police requires, and the Revised School Code, that the school district will report the following crimes events to local law enforcement. And so there are a list of some very specific, and they're mostly on the side of the more egregious crimes that can be committed. And one of those is vandalism or destruction of property. So if a student is caught spray painting the side of a school building, then the school district has an agreement with the Michigan State Police or local law enforcement that they will, in fact, report that incident to the police. So this is something that's specifically in the Student Code of Conduct that we have. And the next question for scenario number 4 was, can the local police department question the student about the incident at school? And yes, the police can absolutely question the student about the incident. Part of the student code of conduct indicates that police departments and local law enforcement agents are allowed to come onto school property to interview students, to interrogate students. That being said, schools, part of what the student code of conduct says is that schools will, as soon as is possible, inform a student's parents that the police are there and that they're interested in speaking with the student. What a lot of schools don't know is that police officers are permitted to talk to students at school without a parent being there, which is why schools should, as quickly as possible, contact the parents. I know a lot of local law enforcement agents also, if parents unavailable, may allow an administrator or someone else at the school district to sit in on the interview as a courtesy, which I think is great. But that's scenario 4. Is there anything else you'd like to add, Kevin? All right.
Sorry, 14 months of doing this, and I still swing and miss on the mute button sometimes.
No,
the only thing I would say about that last piece about police involvement is to double check your policy. There are some policies out there, and again, not to call them out by name, but there are some Neola policies about police interrogation. And I hate having the word interrogation in school district policies, but they specifically say that the police will never be allowed to talk to a student while they're in school. Now, Anya's right, that's not a legal requirement. That's just something that these Neola policies, frankly, create an additional hurdle or a burden for the school district to comply with. And so what Anya said is 100% accurate legally, but your policy might have an intervening standard that doesn't allow that to happen. So just be mindful of that and double check your policies before you allow that to happen. That's all.
Great. All right, scenario number 5. You learn that a new enrolled student was expelled from her previous school district because she was caught smoking marijuana on campus. To your knowledge, she has not violated any of your schools or your school district's student code of conduct requirements. Can you suspend or expel the student for smoking marijuana at her previous school district once she's enrolled at your school? I'll give you guys a couple minutes to think about this and then come back. Maybe just 1 minute.
I'm going to kill the suspense on this, Anya. I've got no idea. I've got no idea. And look, I know these issues come up from time to time. Sometimes they get dealt with at the enrollment standpoint. Sometimes these issues come up after a student's already been enrolled. I mean, I do have an idea, but if I'm an administrator, I'm probably not. Yeah, I'm probably not super clear on this because it's tricky. I mean, that is really tricky, right? Because they've theoretically committed an offense elsewhere, and that behavior, if he or she, it is a she, if she had committed that behavior on our school grounds, it would be a basis for probably suspension or expulsion under our policies and our code. So, I don't know. That's kind of tricky. What say you?
What I say is that actually, yes, you can actually expel or suspend a student who did not commit any violation of your student code of conduct, but did commit one at the prior school that they went to. And that's true even if they were expelled or suspended from that school district for the same conduct. I know this seems counterintuitive. You're like, hey, one time, Sally here, she was caught smoking marijuana. That's unfortunate. She was expelled, punishment served. Why would we be able to expel her? And the answer to that, you don't have to necessarily expel her. But that being said, you are certainly permitted to. And the reason you're permitted to is frankly because the law allows you to. And this is contained under section 1.11 of our model student code of conduct, and is under paragraph 27, which is entitled misconduct prior to enrollment. And so this would, and when this situation usually arises is that if the conduct that occurred before the student was enrolled at your school district, and the language is constituted sufficient basis for expelling or suspending the student at the current district, then you're allowed to do So, and smoking marijuana on school premises is certainly one of those incidences that that all school districts would discipline a student for. So, you are allowed to suspend or expel her for that misconduct.
Yeah, the other thing I would add on this is one that you're probably talking to legal counsel before you take that action, just
Yes.
to make sure that it's good. And somebody popped in the chat here, or the Q&A, excuse me, and mentioned wanting to see what the expulsion notice said from the prior district. What the wording of that was, what the circumstances were, and I've had a number of those situations, not necessarily with marijuana, but trying to figure out what happened in a prior district before they enrolled in our district, to see if it would in fact be a violation. So interesting one, interesting question.
Yeah, and also, to speak more on that, when this new student enrolls at your school district, as everyone in attendance may know, you actually are required to get the student's previous file, their file from the previous school district, which includes all of that disciplinary history. So hopefully by the time the student enrolls and when you learn about this, you have their file, their CA60 file, and you have their disciplinary history in there where you can get that information from. All right, scenario number 6. A student wears a Black Lives Matter t-shirt to school. Some students make negative or positive comments about the shirt in the hallway, and at least one parent at the school complains about the shirt to central office, or to front office rather. Can you tell the student to change out of the shirt? All right, Kevin, as the administrator, do you have any thoughts on whether you can ask the student to change out of the Black Lives Matter t-shirt?
So, wow. So very dicey. I'll try to put my administrator hat on and know that, I seem to recall something about, disrupting school environment, but I'm also concerned about First Amendment. But I also know that there's a lot of sensitivity both ways about, in particular, Black Lives Matter. And I probably would be very, very concerned about telling a student that they needed to change that t-shirt or remove that t-shirt, if for no other reasons than A, I'm not really sure what the law on this would be, and B, I'm confident that if I do that, channel 2, 4, and 7 are going to be out front of my school before the day is over, asking me to answer questions about why I had the student do that. And so this is one where I'm probably absolutely, definitely calling up the central office to ask some questions and asking for the number of Anya Lusk so I can get a good answer.
And those are all excellent things to consider. And even if the thinking wasn't completely in line with the law, the conclusion is correct. Essentially, Kevin spoke at length yesterday about Tinker, about the black armbands. We also spoke a little bit, both he and I, about some more recent examples of when, behavior is kind of disruptive in school. And in this situation, some students make negative comments, some students make positive comments, a parent complains. This would not really rise to the level of disruption based on a student's, what their appearance, what they're wearing, to ask the student to change out of the shirt. And if you do ask the student to change out of the shirt, like Kevin said, you're very likely risking a situation where you may be abridging the student's First Amendment right to free speech. And you may, in fact, have the local news coming down and suggesting that you're not in support of the cause, or whatever the issue may be, whatever they say about it. So I would not recommend asking the student to change out of the shirt if the only things that have occurred are some comments and one parent complains.
Yeah, I think, let me talk as Kevin now. This is a really fantastic scenario because it evokes thoughts about a lot of different things that actually do happen in the school environment, right? And Tinker, as we talked about yesterday, the key phrase is substantial disruption. We're all really bright people. We can take anything that happens in school and say that it's disruptive. We can find a way to suggest that it's disrupting the school day. But the key in Tinker and all the cases that have followed is this idea of substantially disrupting the operation and the functioning of the school. As Anya points out, in this particular scenario, some positive, some negative, no big deal. But let's play this out. What if a kid was walking around with a Nazi symbol on a t-shirt? Would that be different? What if somebody was walking around with a shirt that had the N-word on it? I mean, those are different scenarios that are going to substantially disrupt what is going on in the school building. It is going to create health and safety concerns, and all because there's going to be fights and everything else. Black Lives Matter, certainly there is a message there, but it is not one that is, I think, generally viewed to be as certainly as heinous or disruptive as a Nazi symbol or wearing the N-word or something along those lines. Those are different scenarios. I will tell you that from a legal perspective, one of the hardest cases, and there are cases that are all over the map on this, is the Confederate flag.
Yes.
And what to do with the Confederate flag, and in what environment the Confederate flag is used. Is it on somebody's car in the parking lot? Are they wearing a T-shirt with the Confederate flag on it? So on and so forth. And we all know that the Confederate flag has enough of a history, and there's enough controversy around it that somebody's going to ask the question. But in a lot of these cases that relate to the Confederate flag, the issue has been, how much disruption has there actually been? Right? Yeah, there's always certainly a few people that are like, I don't like the Confederate flag. Maybe they say it makes them uncomfortable, so on and so forth. But how many instances does it really create a substantial disruption? And to be candid, we have had cases, we've dealt with cases that have been, in more rural settings, that there was a few people who objected, but there wasn't a real disruption. We've had certainly cases in much more urban and diverse settings where it's been a real disruption. And so you're almost to the point where you can't say Confederate flag, yes or no. It's Confederate flag, how big is the outcry? Confederate flag, how big is the disruption? And so these First Amendment cases hinge very often on that. Again, the examples I gave at the outset are sort of per se viewed as being inappropriate. But oftentimes it's how big is the disruption? And, does a symbol, does a message, naturally imply violence? Again, I'm not here to be political. Some people might say Black Lives Matter does. Some would say it doesn't. But not like the Aryan nation. That's a different story, right? And so that's some of the thought process and the analysis that we do as legal counsel when these types of inquiries come in. But I think Anya's right on this one. You're probably not asking the student to change their T-shirt for a whole host of reasons, both legal and practical.
All right, scenario 7. I kind of let the cat out of the bag a little bit yesterday with my talk about a recent Supreme Court case, but here is another, a similar type of situation. And so over the weekend, a student posts F school, F softball, F cheer, F everything on Twitter. Very upset by the comment, the cheer coach shows it to the high school principal the following Monday. Can you discipline the student for her Twitter post?
I got to be honest, because having my situation's a little different, having an almost 15-year-old daughter who's not on Twitter. And certainly I would expect that the profanity wouldn't be used in my house, but I kind of think this is her general feeling on everything at this point in life for those of you that have survived a teenage daughter, you know what I'm saying without further qualification. But I think we did let the cat out of the bag a little bit yesterday, Anya, with this, but I think it's whether it's these types of thoughts or other things that are in that off-campus online speech. I know we talked a little bit about the Bell versus Itawamba case. We talked about Tinker. Look, my gut on this as legal counsel is I want to address student online off-campus speech to the extent that I think it does substantially disrupt what's going on in the school. In the same breath, I think we have to be very realistic about what that is. Okay. Do I want anybody associated with our school going out on Twitter and saying, F the school, F softball, F cheer, F everything? Of course not. Of course I don't. Right. But at the end of the day, so what? I mean, is it really disrupting our ability to run school? I mean, do I wish that the student was more enlightened? Do I wish that they had a few more words in their vocabulary to use to share their feelings? Of course. And those are things that we can try to address with the student in a way that doesn't result in discipline or punishment. And I don't want to say we've got to get thicker skin, but I think what we see is sometimes these cases come out in a way that is contrary to what the school wants because the school is overreaching, right? I mean, we don't like it. It's crude, it's offensive, it bothers us, but does it really eliminate our ability to teach chemistry hours 1 through 6? No, it doesn't. Does it eliminate our ability to have an athletic program? No, it doesn't. Now, they were using teacher names, if they called the principal X, Y, or Z, that might be different. And so I think, sometimes in these cases, the districts get in trouble, the schools get in trouble by overreach. But Kevin, we've got to make sure that people know there are standards of behavior. I agree with you. I do. But that sort of thinking, that sort of iron-fisted, zero tolerance thinking is what got us to the point where the legislature has given us 7 factors to think about in a rebuttable presumption against discipline, long-term suspension, and expulsion. And so, I'm not trying to be I'm not trying to be naive. And I say this, and many of you know me. I've got a wife that's a teacher, and I've got a mom that was a teacher and an administrator who was dealing with these things. And so I get it. It is upsetting, but I think we've got to be realistic about it. We don't want to overreach necessarily. We want to be thoughtful about what we're doing. And this probably presents a really good opportunity to counsel the student about how to be, I don't want to say a better person, but more appropriately communicate their thoughts than just, going to the rod and disciplining them. Sorry, those are my thoughts. And again, I get it because we deal with a lot of this stuff, and these are the types of discussions that we have with clients all the time.
Right. I know. Absolutely. And one of the reasons that I included this example in particular, one was because the reasons of Supreme Court case, but also because I kind of wanted to throw in a little bit of a curveball. Generally, I think when we do scenario work, at least when I'm involved in scenario work, there tends to be an example of, yes, this is disruptive, and then no, this is not disruptive. And in reality, this is not all that dissimilar. I mean, the conduct is more, egregious, I guess you could say, although it seems a little bit dramatic of a word, but the conduct is worse, of course, than, obviously than a student wearing a Black Lives Matter t-shirt. But in reality, it seems to have had, at least based on this factual situation, even less of any sort of impact on the school. And while the cheer coach, of course, we want to make sure that the cheer coach isn't upset by the comment. In reality, if this is the only instance of someone coming to the front office and indicating that, that this Twitter comment was posted, a substantial disruption hasn't really occurred.
Yeah, Anya, we got a good question on this case that just popped in here. In the cheer case, we got 2 now. Okay, in the cheer case, isn't the discipline related to playing in the sport, not suspension from school? Isn't sport discipline by a coach different than educational suspension? So the answer to the second question is yes, a sport discipline would be different than a suspension from school. I don't know that our scenario was actually distinguishing between the two. I think we were probably thinking about the idea of, suspending the kid from school.
It was. It wasn't meant to mirror the case perfectly, right?
Yeah, but it's a really great way to think about it, and a good question to ask. So yeah, I mean, the short answer is yes. A sports suspension would be different than an educational suspension, and that would be one way to go. I'm trying to remember the facts of this case, Anya.
And I will say that actually. I'm sorry. I reread the case last night after our discussion about it, so I'd be happy to talk about it.
Yeah, I was going to say, I think she posted that because she didn't make the cheer team, right, or something like that.
Yeah, well, so she didn't make the cheer team, right? But what part of the issue was that whether or not they could discipline her under the athletic code of conduct, and instead of just like the student code of conduct, whether she had violated just the athletic code of conduct and therefore could be suspended from the sport itself. So it's a totally different situation. But the school ended up suspending her, which was the issue.
So another cool, good question on that on the scenario. Even if the school does not discipline the student for that language on Twitter, can the school use that information to inform them of maybe acceptance into the National Honor Society down the road? So in other words, use that later on when it becomes. I'm extrapolating from the question here, but NHS. As an NHS member, one of the things that you're, it's good citizenship. It's a reputation for, operating with fidelity and professionalism and all that good stuff. I would say yes. I would say that's one of the things here about why we need to talk to kids. We need to spend, I don't want to say more time because I know we're already spending a lot of time, but they have a responsibility to be good digital citizens, and they need to understand. I understand they're young, they're 14, 15, they're going to make mistakes, but they need to understand that there are implications for this stuff. And I'll reflect just personally. I mean, my almost 15-year-old does not have social media, and she is on me, and I am the worst dad in the world. And I mean, she's living in a Machiavellian prison here because I won't allow her on social media. And unfortunately, the explanation of your dad's a school lawyer who's seen too much isn't carrying much weight at my house anymore. But what I talk about is everything that you post. You might as well just assume that all these colleges that you dream of going to are going to review your entire feed, that the NHS is going to review your entire feed. And you're a smart kid, and you tell me you're not going to say anything dumb, but you will, because you're a kid, and that's what kids do. And so I think the answer to Bobby's question about can we use it? Yeah, I think we can use it. I think they need to understand that. In the same breath, I do want to give kids second chances. I know they make mistakes. Our entire paradigm from a disciplinary standpoint now is about learning and growing and getting better. And so I wouldn't say, one tweet when you're a freshman should remove you from NHS consideration. But yeah, theoretically, we could. Theoretically, we could. And so, but I think this ever-present need to talk to our young people about being responsible digital citizens and understanding the dire implications. And there's plenty of news articles out there about people who've had sports scholarships withdrawn. We had a case a few years back. Somebody had an appointment to West Point that they lost because of online activity. And so, it's a different kind of world than it was when we were all growing up, and they have to be mindful of that. But I think that would be fair game.
Absolutely. All right, we have one last scenario to go over today, and then Kevin and I will spend the last 10 or 15 minutes answering whatever questions you can possibly think of, and type into the Q&A. So scenario number 8, a student's file contains a written record of a specific instance of misconduct. The student's parent disagrees with the conclusion of the report and asks that the associated discipline be removed from the student's record. How do you respond?
So Anya, I'll play administrator on this one. Because this is goofy. I mean, my gut is, mom disagrees. Well, great. Parents disagree with stuff all the time, particularly when the conclusion is that their kid isn't an angel. They tend to disagree with stuff. But I have a vague recollection of Kevin talking about something about FERPA and being able to amend a student record. And maybe that's something that I need to look into in my legal survival guide to make sure that I know exactly what the lay of the land is, because there is something, if I'm not mistaken, about amending a student record. Is there not?
And how amazing for you that you were able to attend the legal survival guide training so that you're aware that this exists. And you're absolutely right. So this is under section 2.1 of the Student Code of Conduct. It's actually, if I'm not mistaken, also part of the annual notifications. But parents have the right to amend, or ask the school district rather, to amend student records if they are misleading, if they are inaccurate, or if they're in violation of a student's privacy rights. Now, whether or not a report that the parent disagrees with is misleading or inaccurate is going to be up for discussion. And although, as Kevin has said, and I've said multiple times now, we hate to do that, fact by fact or case by case situation, but it really is going to be a case by case situation. So what occurs, and what Kevin talked about yesterday a bit, is, and what is included in the Student Code of Conduct, is if a school district declines to amend a student record, and keep in mind that a parent actually has to submit a written request for the record to be amended. If a student, or if the school declines to amend the record, the parent is entitled to a hearing. So it often comes down to whether or not it's worth, frankly, the effort of having a hearing to decline to amend a student's records. If it's not something that's really a big deal, it's not something that has sort of an impact on the school or an impact on the student's life, or may have an impact on the student's life later, frankly, it might just make sense for everybody involved to say, fine, okay, we'll amend this record, and consistent with how you want, so long, of course, as the amendment is not untruthful. But sometimes it's not always worth the effort to have a full hearing, especially if it's not something that's really a big concern. But the parents are entitled to a hearing with the school board if the school does refuse to amend a record. So that's always something that you want to keep in mind. And how they're made aware of that is that the school actually provides them with notice of a hearing so that they can come and appear. So that is the last scenario that we have for you today. And we have about 10 minutes left. So kind of like Kevin did yesterday, if there's any questions that you guys have about anything we've talked about or really anything else, feel free to type in the Q&A. Our contact information, Kevin and mine, is also on the screen here. Our phone numbers, email addresses, and then our Twitter feed. So if you would like to see what we post about on Twitter, please join us at MJ Ed Law.
Yeah, Anya, great job. And people have asked a number of really good questions. I've been busy typing away here, and I apologize. There was a few times I forgot to mute myself as I was pounding away on my keyboard. We've had over 20 questions and throughout the presentation, and really good, insightful stuff. And I noticed yesterday we did pick up a couple of Twitter followers. And so if you like the Twitter, if you're into the Twitter and you want to get updates, we're sending out stuff all the time. At MJ Ed Law is a great resource to follow. So we'll give it another few seconds here, and while we're waiting to see if any additional questions come in, just want to thank everybody. I mean, again, I mentioned yesterday, MASSP has really been a tremendous partner for us in terms of coming up with new ideas or ways to deliver content, whether it's our monthly legalese article that hopefully many of you get from MASSP, or partnering on this legal survival guide. Many of you are familiar with the Administrator Simulator, which if you're not, send me an email or send Ryan Casey an email, because that's something that MASSP is building up to have different simulations online for administrators to learn from and talk about as administrative teams. MASSP just does so much, and they've been wonderful to us. They are great partners, and they really do a wonderful job for their membership. And so I say that not because Wendy pays me to say it or anything like that, but it's true. They really do a great job, and they really care deeply about their membership. And so we appreciate their partnership. We appreciate they're giving us the opportunity to have this legal survival guide, and then spend the last couple of days with you chatting about it. Anya, we got one that just popped in. I was just about to call it a day, and we had one pop in here. So here we go. It was a long one. That's why it was taking a long time to write. Substantial disruption issue. Number one, what if Black Lives Matter shirt starts a heated argument discussion that turns into a physical altercation? Number two, Confederate flag example, 95% white school, an African-American student takes great offense. Substantial disruption to him or her, or is it a numbers game for disruption? We don't allow it, but I've never been called on it yet. Well, that's a great question.
It really is.
Let me take the Confederate flag question first. So 95% white school, an African-American student takes great offense. Is it a substantial disruption to him or her? Well, it certainly is a substantial disruption to that person, but does it substantially disrupt the school environment and the ability to deliver curriculum? Is it a numbers game? I don't want to come out and say it's a numbers game, but yeah, probably to a certain extent, it is. Now, again, remember, you might have provisions in your policy or in your student code or, in your dress code language that might specifically eliminate somebody's ability to wear a Confederate flag. But if you don't, is it a numbers game? Yeah, a little bit. If I'm being practical, how big is the disruption? And I won't name any communities here, but I had that exact situation where I had, a very predominantly rural white school that only had a handful of minority students, Confederate flag on the truck in the parking lot, and those few minority students were upset, and their parents were upset. Was there a big outcry? Was the school shut down for the day? No. What we tried was to counsel the student and counsel the parents of the student with the Confederate flag about the impact that it had, what its symbolism was, and why it might be upsetting some students. In the majority of cases, we've been able to get moms and dads and students to understand that, to view their actions through the eyes of another person and remove the flag. We've had a couple cases where they've refused to do that, and candidly, where there's not any disruption to point to, it's very difficult to tell them no. You can't have the flag. Some districts have said we're going to tell them no, and if we get sued, fine. And if we lose, so be it. But we'll lose having taken a position that we feel is the right position. We love clients like that. Clients
Yes,
that are ready to willing to die on the hill, if you will, of doing the right thing. And if a judge tells them that they couldn't do it, then so be it. But again, my point here is that it's not a slam dunk. It's not a totally thumbs up or thumbs down. It is a little bit case specific. To the second question of the Black Lives Matter shirt, Anya, feel free to weigh in on this one. I think if you've gotten to the point where there's a heated argument and discussion that's turning into a physical altercation, you might have enough disruption of the school day and the school environment to do something. But what are your thoughts on that?
I agree. I think, though, in a case like this where there is the possibility, of course, again, it depends on the situation, but there's a possibility that an argument or a fistfight was started based on race-based harassment. Then I think we might have a situation where an investigation might need to occur to see kind of what led to the altercation happening. And I think that would be an important thing to do to determine whether or not it's just, because clearly, I think, fist fighting in the hallways is a substantial disruption, but I also think it's important when there are issues of race or gender or any other protected class of people arises, that we also make sure we're not missing the possibility that this could have been based on discrimination or harassment.
Yeah, Anya, that's a really, really good point. That's a really, really good point. And I think it points out the fact that what we see in all this stuff, and we're talking about policy and code and all that stuff, sometimes there's multiple lenses that we need to look through things at, and we've seen that a lot with the Title IX stuff. Anya makes a really, really good point here. It'd be one thing just to look at it from the disruption angle, but we might also have a racial discrimination angle. That's a really, really good point. I do want to make one thing clear. I am not saying that if a fight created substantial disruption, that we want fights so we can address these things. We're not saying that, of course. No. But ultimately, this stuff can be convoluted, and we've got to look at it a couple of different ways. So that's maybe that's a great one. I don't see any others popping in here right now, Anya. Then maybe that's a great one to end on with a very astute insight about really. Yeah, go ahead.
I'm sorry. I do want to say one thing. So the reproductive opt-out form was an excellent recommendation. So, we released the new updates of the legal survival guide, usually at the beginning of each year around, I think, February, March-ish. So at any time during the year, if you have any recommendations, please, by all means, reach out to Kevin, reach out to me. This legal survival guide is meant to help you, of course, school administrators and school principals and those involved, in the school. So if there's something that's missing or something you'd like seeing, please don't hesitate to make some recommendations.
Absolutely. Perfectly well said. I think we end on that. Everybody, it's been a wonderful 4 hours. We appreciate your attention. We appreciate your attendance. As always, if there are questions, feel free to reach out, phone and email listed there on the screen. The video, today's session and yesterday's, will be recorded, will be made available to you through MASSP. And if you have any technical difficulties in downloading or accessing the manual, the Legal Survival Guide, please reach out to MASSP and they will hook you up. Anya, thanks so much. Great to partner with you for a couple of days on this. Did a great job today. And thanks, everybody. Have a great week.
Bye, everyone.